In this video, I want to cover a very common question that we always get asked by people. If my parents are in the US at this time and I'm a US citizen over the age of 21, can I sponsor my parents and help them get an adjustment of status? Well, there are interesting points that we can raise in this issue. First of all, a person who is a US citizen must be 21 years old to be able to sponsor their parents. Common misconception is that just because you have a baby in the United States and that baby is a US citizen, you can use that child to get a residency, a green card, or a citizenship. Well, that is not the case. The child must be 21 to be able to provide the benefits to their parents. The second thing we have to look at is whether the parents are currently in the United States in lawful status or unlawful status. If the parents are in legal status at the time of the child's 21st birthday, then it is possible to file for their paperwork and they're able to stay in the United States and get the green card. But what if their parents are in unlawful status? Well, in that case, what we do is we apply an analysis where we try to figure out whether they entered the US legally in the first place and then they lost their status, as opposed to parents who came to the US illegally. Well, let's look at parents who came here legally. If the parents came here legally many years ago, and then they lost their status. So they came on a tourist visa or work visa, and then they lost their status, remained in the US until the child turned 21, and now they've never left, and they are eligible for adjustment of status. So the child can easily file for their paperwork, even though they are now without status and overstayed. But what about parents that came here without inspection? They came here illegally. So there are several points that we have to look at. The first analysis is whether there's any proof of legal entry. If there's no proof of legal entry, then we have to look at whether the parents qualify what is called Section 245I. Well, Section 245I allows people that came to the US and had a petition filed for them before April of 2001, and they were present in the US in December 2000, to still legalize themselves through a current visa petition, whether it's, in this case, it's a child, as long as they had that previous petition filed for them before April of 2001. If that is the case, they're able to use their child to file for their adjustment of status, and all they have to do is pay a fine. Another way to help people that came here illegally is if they had what is called a previous work permit based on the agricultural programs. In the 80s and before that, many people came to work in the US as agricultural workers. They had a work permit, and they were able to enter in and out using that work permit. That work permit constitutes legal entry, and so those people that had those cards expired and they're still in the US at this point, they also may be able to benefit from an adjustment of status using their child's citizenship. Any other person that does not meet those requirements will need to depart the US and file for their petition using the US Embassy in their home country. The problem is that once the parents depart the US, they're going to be barred for 10 years because of an overstay, and they're going to be subject to penalties. And those are complex issues that require consultation with an immigration attorney to determine whether these parents will qualify for any sort of a waiver that would allow them to return back to the US. Again, to conclude, there are ways for parents who are currently in the US to adjust their status if their kids are over the age of 21. Hopefully this information was beneficial to you, and if you have any questions, please post them in the comments below, and we look forward to hearing back from you soon. Thank you.